Oh, let's go up to the federal level now and look at the Creator Act. Yes, it's another backronym. The Creative Rights Ensuring Artists' Technique and Originality Are Reserved Act. Yay, another press release, quote, designed to safeguard visual artists from the unauthorized commercial exploitation of their unique and creative artistic styles in the age of artificial intelligence. In other words, designed to destroy free speech and fair use. Congresswoman Beth Van Doyen bleated, artists, illustrators, and designers in every district are watching their livelihoods be undercut by AI tools deliberately impersonating them, but right now, the law has no answer for it. These are people who have spent a lifetime building their creative identity. They deserve protection. I have heard loud and clear that this is a growing problem across the country, and the Creator Act is a direct response. I'm glad to be leading this bipartisan effort alongside Representatives Clark and Fushi, taking direct aim at the bad actors who knowingly use AI to fake an artist's identity for commercial gain. Yes, once again, we're talking about the movement to make a style protected by copyright. And as we've covered many times, that would suppress and stifle artistic voices, not protect them. It would only mean protection for the giant copyright cartels that want to control every single thing you see and hear. And the press release is full of, wah, I've been an artist for 10 years and I want my style protected, wah. Oh yeah? Well, I've been an artist for 40 years, 31 if you count just the years since I got my degree, and I say, fuck you! Styles must not be protected if we want artistic expression to flourish. The bill would create a completely new kind of copyright on top of existing copyright and trademark laws to make style impersonation an infringement and to protect an artist's visual identity. What the heck? Let's read the actual text. Quote, the right established under this section is a federal intellectual property right distinct from copyright and trademark. Yes, it's a whole new form of IP. Not copyright, not trademark, completely new. And guess what? You still get protection of your visual identity for 10 years after you die! The infringing acts are defined as, quote, intentionally configured for the purpose of generating stylistic impersonations of one or more visual artists, and promoted as capable of generating such stylistic impersonations. But that kind of impersonation is exactly how art movements are made and flourish. And the problem is that this stylistic impersonation as a practical matter cannot be defined in a way to avoid chilling lawful creativity. So that'll be up to judges and maybe even juries to try and have to parse, with no guidance and the result being no consistency in enforcement of the law. And yet, at stake is statutory damages of, quote, not less than $10,000 and not more than $100,000 per stylistic impersonation work commercially exploited. Yikes! So we're talking about potentially millions in statutory damages for what ultimately are irremediable 5th and 14th Amendment violations. And how does Congress even have the power to create such a right? Copyrights and patents are authorized by Article 1, Section 8, Clause 8, which gives Congress the power, quote, to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Nowhere does the Constitution give them anything resembling the right described in the law. And since Congress's mandate is to promote the progress of science and useful arts, since this bill inhibits the arts, it's unconstitutional on its very face. In fact, the bill is so terrible, even Adobe loves it. Quote, the Creator Act would be a new arrow in the quiver, helping to ensure that the creative economy that feeds AI innovation isn't hollowed out in the process. They're addressing something that affects every creator working today, and by extension, every industry, brand, and platform that depends on human creativity to thrive. We urge Congress to move quickly to advance this important bill. Yeah, Adobe is so concerned about artists, and not at all about competitive AIs that threaten their bottom line. Style has never been considered something protectable. In fact, artistic style has always been declared as protected by the First Amendment. In Baker v. Selden, the crucial idea-expression dichotomy was set up, limiting copyright protection to expression only. The Starr v. 20th Century Fox rejected using trademark as a backdoor copyright, with the court warning against creating a mutant copyright that inhibits free expression. Hurley v. Irish American Gay, Lesbian, and Bisexual Group of Boston established that artistic and expressive choices are protected speech, and in Texas v. Johnson, they warned that the First Amendment gives no exception for expressive content, which means that no such law can be valid absent another constitutional amendment. Yes, there are laws about rights of publicity, but those cases are only about instances of direct forgery or misrepresentation. If I sign John Smith's name or claim it was painted by John Smith, that would apply. But in the style of John Smith is phraseology artists have used for centuries. It's been well accepted and well established in artistic circles, and I'm unaware of anyone complaining about the concept at all prior to AI. Which tells you that this is not about protecting artists at all. It's yet another attempt by the Neo-Luddites to regulate and restrict AI, which would be the worst thing possible for the creative minds of the future.